Hello, my name is Robert Goodwin, and this is Law on the Line. I would like to welcome my guests, Jeffrey Gerstenblatt, and Jeffrey is an attorney in Lakewood, New Jersey, who specializes in general litigation, but specializes in collection law. And I'd like to welcome back David Greenfield, and David has been a guest prior to this particular show, and his expertise is mediation, litigation, and general knowledge. I'll leave it at that. And so today we're going to be talking about judgment collection, and I thank Dave for providing a questionnaire or sort of a text for today. And he said that let's talk about now a judgment, what is next? So we have a judgment, what is next? And Dave, just summarize very quickly about the process of getting a judgment. And since we're talking to a general audience here, many times judgments are in the special civil part, and of course the law division, but they're more than, generally speaking, $20,000. Let's focus on special civil part, judgment, and just talk about that very generally right now.
Okay, a judgment will arise after a lawsuit, usually tried before a judge. It's where somebody is seeking money for, it could be a credit card company, it could be a bank, it could be a doctor who's seeking money for any amount of medical bills that are not covered by insurance. You'll see contractor disputes, but basically it's a suit for money. Now, after the judge hears both sides, the judge will render an opinion, and let's say in this case, the judge finds for the plaintiff. The plaintiff is the person who brings the suit, and will say, well, I find for the plaintiff in the amount of X dollars. And that finding is reduced to a paper called a judgment. If directing the defendant to pay X dollars. If the defendant pays the X dollars, it's over. What happens if the defendant doesn't pay?
All right, now I'm going to bring this to Jeff's forte, which is really collection practice. And there's two prongs. One prong, of course, is two sides to a story. One person is the judgment creditor, the plaintiff perhaps, or the defendant, it depends. And the other person is, of course, the debtor. So from the point of view of the judgment creditor, you have this piece of paper. And so the first question I'm going to ask is, if you have this piece of paper, I've got a judgment of $5,000 against the old days aluminum siding contractor. Do I get paid that day in court, Jeff?
No.
Okay, let's talk about that. What happens?
I always tell my litigants there is no window at the courthouse where you hand them a copy of your judgment and they hand you a check or count off some nice, crisp bills for you. The first thing
Venmo.
No Venmo.
Okay, go ahead.
The first thing you are required to do is send a copy of the judgment to the defendant, and I always send it with a request that they pay it. If they don't, there's a number of things that you can utilize. There's something called an information subpoena, which are written questions. It's a standard form by the court.
And that's in the rules, right here.
That's in the rules.
And I want to show everybody the 2025 court rules.
Correct.
Thousands of pages, by the way.
Correct. And you can send that to the creditor. They are required to answer that. And they are required to disclose where they work, the address of where they work.
Send that to the debtor.
Send it to the debtor,
yes.
Correct.
Mm-hmm.
If they don't return that in 14 days, you can file a motion with the court to compel them to answer that.
So what is the information that you're asking for?
You're asking for their financial history, not so much history, but their financial information. Do they own a car? Where do they bank? Things like that. The purpose being that you can do something called wage execution. You can execute on 10% of a debtor's salary, but the courts will only do one wage execution at a time.
You mentioned that's like a queue. If you have more than one, you get on
Correct.
that queue.
You may be backed up, and it winds up being a very small amount that you get doing that. People also leave jobs and go to other jobs. You can also execute on a bank account. A personal bank account, not a corporate bank account, but a personal bank account has a $1,000 exemption. So the debtor would need to just write a letter to the judge and send it saying, I want to exercise my $1,000 exemption. So if you were to execute on a bank account and it had $2,000 in it, you would only be able to get $1,000. Also, there are court officers' fees that have to be paid out of that as well.
So that's from the point of view of the judgment creditor. So it doesn't seem to be that a real quick turnaround to get your money. There's hard work. So you're representing a judgment creditor. In addition to sending out the subpoena, what else do you do to try to secure a payment? And you mentioned something early when to file a lawsuit about identification, what kind of entity you are.
Mm-hmm. It's very important, especially for commercial clients, business clients who are working business to business, that they ask when I call it the I love you period, when we're all going to do business, everything is good between you. What's your corporate name? Because lots of times people will go by a trade name. Are you a corporation? Things like that, because you want to know who you're suing and who you're doing business with. So that's really important. It's really important, and doctors' offices do this, attorneys' offices do this, is to get people's social security numbers if you can, dates of birth, because there's a law called the Soldiers and Sailors Act. So I have to get a certification to get a judgment from the Department of Defense saying this person's not in the military. You can't get a default judgment against someone who's active in the military.
That's a default judgment.
Correct.
As opposed to a judgment where a person
Correct.
appears.
But generally, it's important to get all of that information. It's important when you execute on a bank account because the bank wants the person's social security number to make sure it's the right bank account. And things like that are important.
Just a question. A bank gets a notice from the sheriff of a levy, right?
Mm-hmm.
And then there's an application for a turnover order. Is that it?
Correct. What the bank will do is freeze the account.
Immediately.
They will freeze the account, which can cause the debtor to bounce checks. And then the creditor has to do something called a motion for turnover, asking for the turnover of funds, and that's brought before the court. The debtor has a right to object to that, and there are certain things that you cannot, if they're in the bank account and you can prove that what the money trail is, they cannot execute on, such as retirement funds, Social Security, things like that. You cannot execute on.
Alimony?
I believe you can execute on alimony.
Okay. Yeah. What about the $1,000 exemption you talked about? Is that something that the bank will tell the lien hold, the sheriff or the party executing? How does that work?
No. What's going to happen is you're going to get a letter from your bank if you're the debtor saying that your account's been executed on. Then you're probably going to get a letter from the court officer, which is going to explain about the $1,000 exemption and what you have to do
to assert that.
To assert that.
I got it.
Correct.
So, Dave, have you ever been in a situation where you had to go through this process and to collect a judgment, or?
Many years ago, I'm licensed in New York, and I did work for some collection attorneys, and this process was somewhat similar. It's long, it's arduous, and some very often not very successful. But one thing that acts as a good lever is the ability to docket the judgment. And Mr. Gerstenblatt can run us through that.
Okay, so let's talk about that. Now you have this judgment, and you've talked about, briefly of course, trying to execute wage garnishment, bank levy. What is the power of a judgment which is docketed, and how do you go about doing that, both in the special civil part, which is under $20,000, or in the Superior Court Law Division?
Okay, for a special civil part, and people need to know, judgments are good for 20 years. So the law doesn't necessarily contemplate an immediate payment. they can be renewed for another 20 years. When you have a judgment in the special civil part, you can send a letter to the clerk of the special civil part in whatever county you have your judgment and request what's called a statement for docketing. We call it in New Jersey docketing. You're recording the judgment.
Okay.
And you get that statement, you fill it out, and there's a $35 fee, and you send it to Trenton. There's an address where you send it. Actually, it's all electronic filing now. They don't even want
and we're talking
you to
about
mail
that
it
through
to them.
JEDS now.
You do use JEDS to do it, and you will have then you will create a lien, a statewide lien on all real estate. It's a little different in Superior Court in the law division. Judgments over $20,000. You take your order of judgment that is signed by the judge, and you send it also with $35. You have to send a copy of that order, and there's no docketing statements in law division. And you send that to Trenton, same place, the judgment section, and they will record it as a lien. And you usually will get it back if you put in not even anymore. They'll email it back to you.
Nothing is in mail.
Right. And they'll say it's recorded as a lien.
And that's good for 20 years.
Yes.
And now if somebody has said, you know what, I'm not going to do a wage execution, it's hard, the person is somewhat itinerant, banks, I did a credit check, there's a very seemingly low balance. What does the judgment then do? You call it a statewide lien. Mm-hmm. How does that affect the judgment debtor?
It will affect it in two ways. It will affect your credit and be on your credit report. So if you apply for a mortgage, a car loan, anything that requires that type of credit approval, you may have a problem. You may still be able to get credit, but the most reliable credit agencies where you're getting, the local bank, is going to want you to have good credit. The second thing is it's a lien on real estate. So if you go to sell a piece of property that is in your name in New Jersey right now, you do have to satisfy that judgment. There are states where judgments don't automatically attach as liens. In New Jersey, they do.
I know that we live in a state where there's many people own homes, but there's a very large degree of renters. Mm-hmm. From your respective practices, how does a judgment affect a potential tenant? And
well, many landlords now will do a credit report. So if they do a credit report and this judgment comes up, they may not be able to rent that property.
And by satisfying that judgment, if you can, I assume then your credit report will reflect that.
Mm-hmm. When your credit report, it will show that the judgment was satisfied.
Is there anything that the debtor himself or herself has to do to make that happen?
Not necessarily. You can always call the credit card if you get your credit report and something was satisfied and they don't have it down as that. You should call them and you can fix that.
Now, Dave, I know that you do a lot of mediation, and what that is before a judgment is even entered. And anecdotally, you talked about a situation involving an estate a little bit earlier. But when you mediate, I know you, Jeff, and Dave mediate. How do you approach a case where it's either going to be all or nothing with a judgment, or something other than a judgment that may satisfy both parties by way of a mediation settlement? And how does that enforce?
I can answer that. The plaintiff, I would tell the plaintiff who, this is before anyone becomes a judgment creditor or a judgment debtor, because mediation occurs before the case goes to the judge. And I will tell the plaintiff, look, if you get a judgment, again, there's nobody in the courthouse handing you the money as you leave the courthouse. You've got to, if you don't get paid immediately, you've got to go chase this person. You got to do X, Y, and Z, and it's a long, arduous process, and not always successful. On the other hand, so I tell the plaintiff, I said, well, if you lower your demand, maybe you'll get the defendant to settle, and the defendant will very often pay the settlement. Sometimes the settlement is paid in front of the mediator. It happens on occasion.
Through a check, so we don't take credit cards.
I had that today. I was mediating a case, and the person pulled out cash, and we settled the case right there.
No, I've seen that before too.
And of course, that short circuits the whole process of the collection effort, and it's a way of compromise. So,
if I could add,
yes, please.
Then I sometimes will turn to talk to the debtor. It might pay to come up with an amount that you could afford, because if the plaintiff is able to prove the full amount of the claim, you may not be able to pay it, and you could also avoid having a lien on your real property. You could avoid a weight execution. You could avoid a bank execution. And sometimes, and if you both agree to a compromise, you could write a stipulation of settlement. There's no judgment. There'll be no liens. There'll be no sheriff. And what happens?
No.
What happens though if you tell the defendant, if you don't pay?
Well, that's one to throw that back to Jeff.
Okay,
Jeff. If that was the question I was going to ask, Dave has mediated a case. He's done a good job. Stipulation of settlement, $5,000 demand, and the creditor agrees to pay $3,000. You prepare a stipulation. It's a signed document, goes to the judge approves it, right? Firstly, is that reduced to a judgment, the stipulation of settlement?
No judgment on if you settled.
Okay. Secondly, how do you enforce that stipulation of settlement?
Okay, if let's say there's a $5,000 case and they're going to pay $4,000 as a settlement, you could do payment plans too, but in 10 or 15 days. Well, all settlements come with a standard default provision that says that if the person, the debtor, does not make the payment, then the creditor can file a certification or an affidavit with the court, say the person breached the settlement, and they don't have to pay $4,000, they have to pay $5,000 because that's the amount that they sued for. No trial. The judge will see that the person didn't honor the stipulation of settlement and enter the judgment for the full amount. The way I put it to debtors is this is great. We have a settlement. You get your discount when you make your final payment. So if you pay that $4,000, the case is automatically dismissed, gone. But if you don't make that payment, then the creditor can ask the judge to enter a judgment for the full amount that they sued you for.
Now, these are forms that the court generates. Is that correct?
Forms that the court generates, and I settle many, many cases and file stipulations with the court before they ever get to court.
Right. So as an attorney, and you do a lot of collection work, you actually have your own form of stipulation, and you have these provisions in there. Now, how long does the judgment creditor have to make a demand? For example, I'm in default. I haven't paid my $4,000 by the 30th day. What's next?
There's.
What do I have to do?
The judgment creditor?
Correct.
There's no deadline for when you have to file that certification with the court, but you should do it immediately. A judge might see it if the settlement's been sitting there for 6 months or a year or whatever, and the judge may have an issue with that. So you should, if you don't have your payment, sometimes settlements have grace periods in them.
Sure.
But when that grace period is over, then you should act. I, as a rule, always reach out to the debtor first before I do that, because they just may have been slow in making the payment. It may be in the mail, something like that. They may need an extra day or so, but I wouldn't extend it much longer than that.
And then when you now moving on that stipulation, the next step is to reduce that to a judgment by the default provision.
Correct.
Okay.
Correct.
So,
if I may add,
yes, please.
What else a judgment creditor could do is have the sheriff seize personal property that is not exempt. I believe such things as clothing, perhaps a certain amount of money, and
That's exempt.
yeah, that's exempt. But let's say the debtor has jewelry or has a nice car that which is not is not subject to a lien, or some kind of valuable antique. The sheriff could seize that and sell it at an auction sale.
So let me ask Jeff.
That's a very complicated process to do that. It can be very expensive
for the creditor.
No, it is possible, but it's
so just very briefly. How this is from the debtor's point of view. Hasn't paid a debt. How much realistically? How does that debtor realistically have to fear that his car will be seized, his jewelry will be seized, some of his personal assets?
Well, the car has to go through motor vehicle in order to do that. And the reason I don't execute on a lot of cars is most cars have liens on them.
Correct.
So if there's a lien on it, you're going to be behind that other lien on the car. It's a question of value. It's a question of supplying the people, because the sheriff isn't movers. They're not moving the stuff. You have to do all of that. So it gets very complicated. I don't think that's a great fear. I think a bigger fear would be your bank accounts and your wages. And a debtor probably doesn't want their employer to be served with a wage execution. My feeling.
If I may say, a debtor sometimes will be advised to avoid these judgments and avoid any further action if the debtor files bankruptcy.
Yes.
Well, that's always the extreme position that people take.
If the debtor doesn't have that, I suppose, that much property that's subject to be seized, the debtor may say, "Well, it might be a good idea if I file bankruptcy." There's a straight bankruptcy where the assets will be accumulated by the trustee, and most debts, including judgments, correct, can be discharged. And except for certain debts can't be discharged. I think alimony is one of them.
Mm-hmm. Child support.
Student loans and taxes.
But there's another plan called the Chapter 11, where...
or 13.
13, I'm sorry. Chapter 11 applies to businesses. Chapter 13, which is a wage earners plan, where a plan is put together under the approval of a court, where a person pays all the debts over a period of time at perhaps a reduced rate. But what's very important to note is once the bankruptcy proceedings are started, something called an automatic stay goes into effect. There could be no more
collection actions,
no more attempts to enforce the judgment.
Jeff, in your practice, how often are you stymied by a bankruptcy? Is that something that comes up very often?
Surprisingly more often than one would think. Bankruptcy is very common. I would say maybe 1 out of 100 or something like that of the cases that I do, but it certainly is something that you consider. You have to stop. So people who are creditors who are representing themselves, if they get that bankruptcy notice in the mail, they must stop any collection action. Sometimes in a Chapter 13, you will be able to file something called a proof of claim with the court. And you should fill that form out. It's provided by the bank, or you can get it through the bankruptcy court website. And it preserves your rights as a creditor. And if there is money that can be dispersed to, we call them unsecured creditors.
Correct.
Unsecured creditors, then you will maybe get something in the bankruptcy. A number of times I haven't gotten dollar for dollar, but I've gotten payments from the bankruptcy trustee.
Now, Dave, Jeff, as a collection attorney, I notice on letterhead, et cetera, there's like a caveat, explanation. Yes. What is that explanation? And explain to our audience about the Fair Debt Collection Procedure Act, very briefly.
There is a Fair Debt Collection Act, which is a federal act, and all states kind of have different requirements of who has to comply with it. In other words, a person who is representing themselves, and it has to be a consumer debt. A person, let's say a doctor's office or a dentist's office that is representing itself. In New Jersey, you don't have to comply with the federal collection laws, but in Pennsylvania, you do.
Okay, so we're in New Jersey.
I, as a professional debt collector, whether you're a collection agency or a collection attorney, however you do it, must comply. That notice is on every communication that you send, and it's simply saying that this correspondence is from a debt collector, and that any information that you were to give to me, I could use to collect the debt. But you could go back. You have to send a 30-day letter, which has many requirements in it that specifically what has to be put in that letter. And then you have to wait 30 days. They can ask you to verify the debt. You send them a copy of the debt and things like that before you can take any legal action.
And this is against a consumer debt.
Consumer debt. Anything that has to do with a consumer debt.
Okay.
Your contractor, your dentist, your doctor, your lawyer, those are all consumer debts.
What about if I bought a television set from Best Buy, I don't pay Best Buy, but I put it on my charge card.
Consumer debt. And the credit card company, if you don't pay your credit card bill, can sue you.
And you're retained by the credit card company under those kinds of circumstances.
Correct.
And okay. And when you have telephone communication with the debtor, is there any disclosure that you're required to make?
Yes, I am. First of all, I don't cold call. In other words, I don't just call a debtor out of the blue. They have to call me, leave a message or whatever for me to communicate with them. And if I were to be calling them back, I have to identify myself as a debt collector.
What about a debt collector? Other than you're an attorney, so you have there's a different standard. Are they governed by any different standard?
Same rules.
Or same rules.
Same rules.
I just got the notice that we have 1 minute left, but Dave wrote something about new collection law involving medical professionals. What is that all?
I don't think I can do it in a minute. There is the Louisa Carmen or Carmen Louisa Medical Collection Act that was signed by Governor Murphy on June 22nd. The short answer is it's really going to be difficult for doctors to be able to collect in New Jersey. On June 22nd, 2025, it goes into effect 1 year from now, or approximately 1 year from now. Judgments will not, medical debt will not be able to be reported to credit agencies, so it won't go on your credit. They will not be able to do wage or bank executions, and medical judgments will not be liens on real estate. So basically, the judgment will be a piece of paper. It's going to be a very difficult thing to collect. Right now, medical judgments cannot be reported to credit anymore.
Right now?
Right now.
That's a change in the law.
As of July 22nd, 2024.
So is it, in your opinion, as an attorney and a creditor's attorney, does that emasculate the ability of a doctor? We're done. We have to wrap it up.
No question. I've advised a lot of doctors, dentists work on payment plans, and I've advised them to stop doing that, and they have to get their money up front. These are my clients. I think that in the short run, there was a big signing ceremony. Everyone, great. Patients will no longer have to
pay their bills.
But in the long run, I think it's going to have two effects.
Quickly.
People who can't afford to pay the doctor is not going to be able to get a payment plan. And doctors and dentists are not going to want to set up their new practice in New Jersey.
Gotcha. Okay. Well, I'm glad I got that one in because that's very relevant. And thank you, gentlemen, for for me, very edifying. Hope it's for our guests as well, our audience. And I thank you both for coming.